Iowa has a moderately regulated late fee framework with specific guidance from the Iowa Uniform Residential Landlord and Tenant Act. The governing law is found in Iowa Code Chapter 562A, the URLTA, along with general contract principles. If you're a landlord or tenant in Iowa, the state provides meaningful structure through the URLTA. Though the specific late fee provisions leave some details to the lease and case law, let's start with the basics. Iowa does not impose a specific statutory dollar cap or percentage cap on late fees. There is no rule in the URLTA that says the fee must be under a certain amount or percentage. However, the URLTA does provide important guidance. Under Iowa Code Section 562A.9, a rental agreement may not contain provisions that are unconscionable, and an excessive late fee can be challenged as unconscionable. Iowa's unconscionability standard gives courts broad authority to evaluate late fee provisions. A fee that is grossly disproportionate to the landlord's actual damages from late payment, or that takes advantage of the tenant's unequal bargaining position, can be struck down as unconscionable. This standard is more tenant protective than a simple reasonableness analysis because unconscionability considers the overall fairness of the transaction, not just whether the fee approximates actual costs. Iowa does not mandate a specific grace period by statute. There is no state law requiring a defined number of days before a late fee can be charged. However, Iowa's practical customs and the unconscionability standard effectively encourage a grace period. Charging a late fee on day 2, while technically possible, could be viewed as part of an unconscionable fee structure when combined with a high fee amount. Most Iowa landlords include a grace period of 3 to 5 days. The reasonableness standard also applies under general Iowa contract law. A late fee is a liquidated damages provision, and Iowa courts apply the standard 2-part test. The damages must be difficult to calculate precisely at the time of contracting, and the fee must be a reasonable pre-estimate of anticipated damages. A fee that fails either test is an unenforceable penalty. What's reasonable in Iowa? The state has a moderate to affordable rental market. Rents in Des Moines typically range from $800 to $1,400. Iowa City is somewhat higher due to university demand. Cedar Rapids, Davenport, and other cities are moderate. Smaller communities are very affordable. A flat fee of $25 to $60 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible. The lease must clearly state the late fee terms. Under the URLTA, the rental agreement must document all fees and charges. The lease should specify the rent due date, any grace period, the exact fee amount or formula when the fee triggers, whether additional charges apply for continued non-payment, and whether the fee is defined as additional rent. A late fee not specified in the lease is not enforceable. Iowa's URLTA specifically prohibits certain lease provisions. Under Section 562A.11, a rental agreement may not contain provisions that require the tenant to waive any rights under the Act. A late fee provision that effectively waives the tenant's right to challenge the fee's unconscionability, such as a clause saying the tenant agrees the fee is reasonable regardless of amount, would be void. Compounding late fees in Iowa must satisfy both the reasonableness and unconscionability standards. A single one-time fee after the grace period is the safest approach. Daily or weekly compounding that accumulates to a disproportionate amount faces challenge on both grounds, as an unreasonable liquidated damages provision and as an unconscionable lease term. Most Iowa landlords use a single flat fee. The interaction between late fees and the eviction process in Iowa is governed by the URLTA. Under Iowa Code Section 562A.27, the landlord must provide a 3-day notice for non-payment of rent. If the tenant fails to pay within 3 days, the landlord can file for eviction through the court, known as a forcible entry and detainer action. Iowa's 3-day notice period is one of the shorter timelines, meaning the eviction process begins quickly. Whether unpaid late fees can be included in the 3-day notice depends on how the lease defines them. If defined as additional rent, they can be included. If not, the landlord may need to pursue them separately. Best practice. Define late fees as additional rent. The 3-day notice gives the tenant an opportunity to cure by paying the full amount owed. The cure amount must include only compliant late fees. An inflated demand that includes unconscionable fees gives the tenant grounds to challenge the notice, and Iowa courts will evaluate the fee under the unconscionability standard. Iowa has a specific provision regarding the landlord's obligation to mitigate damages. Under Section 562A-29, the landlord must make reasonable efforts to mitigate damages, which primarily applies to abandonment and early termination situations rather than late fees. However, the mitigation principle reflects Iowa's overall approach of limiting the landlord's ability to accumulate charges against the tenant. Iowa limits the security deposit to 2 months' rent. The deposit must be returned within 30 days with an itemized statement of deductions. Unpaid late fees can be deducted if the lease authorizes it and the fees are reasonable and not unconscionable. Failure to return the deposit within 30 days or failure to provide an itemization can result in the landlord being liable for up to twice the amount wrongfully withheld. For tenants receiving Housing Choice Voucher Assistance, Iowa landlords should not charge late fees when the Housing Authority's portion is delayed due to processing. The tenant cannot control the authority's timeline. If the tenant's portion is paid on time, the fee should apply only when the tenant's own payment is actually late. Iowa does not have a major active duty military installation. However, the Iowa National Guard is active. Camp Dodge near Johnston serves as Guard headquarters, and the Rock Island Arsenal, technically in Illinois but drawing Iowa residents, generates some defense-related demand in the Quad Cities area. The SCRA applies to any activated Guard or Reserve member renting in Iowa. Iowa's agricultural economy is a dominant force that affects late payment patterns across much of the state. Farming communities depend on seasonal income. Cash flow is strongest after harvest in the fall and tighter during planting season in the spring. Workers in agriculture, agricultural services, and agricultural processing may have income that fluctuates with the farming calendar. Some Iowa landlords in agricultural communities adjust rent due dates to accommodate seasonal income patterns, setting the due date later in the month when agricultural payments have typically been received. This reduces late payments and the need for fee enforcement. The meatpacking and food processing industry, concentrated in communities like Waterloo, Marshalltown, Perry, Storm Lake, and Denison, employs a large workforce including immigrant populations. These workers need affordable housing. Late fee amounts in these communities should reflect the local economic conditions. Modest rents and modest incomes require modest fees. From a practical standpoint, Iowa's rental market is moderate and dispersed across several small to mid-size metros. Des Moines is the state's largest and most active market. The economy is driven by insurance, including Principal Financial Group, EMC Insurance, and Allied Insurance, financial services, healthcare, government, and a growing technology sector. Rents in desirable Des Moines neighborhoods, the East Village, Ingersoll, Sherman Hill, West Des Moines suburbs, typically range from $900 to $1,500. Most Des Moines landlords charge flat fees of $35 to $60 with a 5-day grace period. The professional tenant base, drawn from insurance, financial services, and healthcare, generally pays reliably. Late fee enforcement is standard but limited to a small percentage of tenants. Iowa City, home to the University of Iowa, has one of the tightest rental markets in the state. University demand drives pricing above what the city's size would normally produce. Student late payments correlate with financial aid processing at the beginning of each semester. The university's large international student population may have additional payment timing issues related to international wire transfers. Cedar Rapids, Iowa's second-largest city, has a moderate market driven by manufacturing, healthcare, and Rockwell Collins. The 2008 flood significantly affected the rental market, and flood risk continues to influence housing decisions. Late fee dynamics are standard. The Quad Cities, Davenport and Bettendorf on the Iowa side, have a moderate market influenced by manufacturing, healthcare, and the Rock Island Arsenal. The cross-border metro means some tenants and landlords interact with both Iowa and Illinois law. Ames, home to Iowa State University, has a tight student market. Waterloo-Cedar Falls has a moderate market with University of Northern Iowa influence. Sioux City has a moderate market influenced by meatpacking and agriculture. Dubuque has a growing market with tourism and healthcare demand. Council Bluffs, adjacent to Omaha, has a market influenced by the Omaha metro economy. Smaller Iowa communities, Fort Dodge, Mason City, Burlington, Ottumwa, Muscatine, have affordable markets with limited demand. Late fee amounts should reflect the local economy. One best practice for Iowa landlords: set your late fee at a level that satisfies both the liquidated damages reasonableness test and the URLTA's unconscionability standard. These are overlapping but distinct analyses. A fee of 5 to 8% of the monthly rent is defensible under both standards. A fee that significantly exceeds your documented costs risks being struck down under either test. Another best practice: include a grace period of at least 5 days, even though Iowa doesn't mandate one. A grace period strengthens the overall reasonableness of your fee provision and reduces the risk of an unconscionability challenge. A landlord who provides no grace period and charges the maximum defensible fee is pushing both limits simultaneously, which is riskier than being generous on one while being firm on the other. A third best practice: document your actual costs for late payment processing. Iowa's unconscionability standard evaluates the overall fairness of the fee provision, and documented costs are strong evidence that the fee is fair. If you can show that a late payment costs you $35 to $45 in staff time, system processing, and follow-up communication, a fee in that range is virtually immune to challenge under either legal standard. For the complete guide to Iowa late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.